Hello, everybody. It's Charles from Nowak Migration. 26th of November, Sunday. Actually, I decided to spare a couple of minutes of my time and have a chat with you about questions, answers, which questions which are posted on the group. So I will give answers. All right. So what have you got there? Australian visa migration education support group, 270,000 people, and a lot of interesting questions. Hi there. I was planning to come to a working holiday visa to Australia after my time now in New Zealand, but I just discovered that I am pregnant. I want to get some information regarding. Can I still apply for a working holiday visa in Australia, even if that means I will give birth in Australia? Yeah, no, the problem with that. You can get the visa to Australia. You can get working holiday visa to Australia, gives them the work, even give birth there. Yeah, listen, it all depends what sort of country of origin, what is your passport, what is your qualifications, work experience, occupation, and so on and so on. If you will give the birth for the kid in Australia, the kid will get by the operation of law will have the same visa as you are having, which is working holiday visa. Interestingly, and yeah, giving birth in Australia, if you're on the temporary visa, could be quite costly. If you're going to be the single mother, it could be quite challenging to, um, be in Australia, live in Australia, trying to make a living and taking care of the child at the same time. If you have got the partner, yeah, different story. But you are not mentioning about your partner. So here's the question: have you got a partner or not? On bridging visa while waiting for PR visa grant gives birth in Australia, what will be the nationality of the child? The nationality of the child will be the same as your nationality, we can assume. So you will have to get the citizenship of wherever you are from. But the thing is, and quite a lot of people are missing this bit on bridging visa while waiting for PR visa. If the kid will be born in Australia, the kid will have the same visa as you are having by the operation of law, but Home Affairs don't know that you are having the kid, right? So just make sure that once the kid will be born, or even before the kid will be born, advise Home Affairs that you are pregnant and you are due, and give them the date. So they will either wait or, yeah, permanent residency. Actually, you want to give the birth after getting the permanent residency, because then the child will become a citizen. But if you're waiting for the temporary visa, that would be a different story. But here is the question about the PR visa. Yeah, listen, if you will give the birth before the permanent visa grant, make sure that you will let Home Affairs know straight away that you gave the birth, even before getting the birth certificate, because you want to avoid the situation where the visa will be granted and your child will be left behind. In such a situation, you can apply them for the child visa if the child wouldn't have any visa. But yeah, if you will give the birth while on the bridging visa, then make sure that you will get the bridging visa for your kid also, and you will have to add the kid to the pending application. Okay. Can I lodge 462 visa application while holding 189 visa application? Yes, you can. You can lodge for a 462 work and holiday visa while lodging 189 visa application. All right. So here it's not clear. While before 189 lodgement or after 189 lodgement, or are you asking about EOY? Did you get invited or you didn't get invited? While lodging, while waiting for 189. If you have lodged 189 already and you are waiting for the decision, yeah, you can listen. You can apply for the 462 and you can get it granted anytime before lodgement of 189, when you have lodged the EOI for 189, and so on and so on and so on. The question over here probably should be asked while waiting for 189 visa decision after lodgement. Okay, yes, you can, but why am I so picky over here? If you would have lodged 462 while waiting for 189, you can come on 460 to 462, but then you will have no bridging visa. Let's say if you will apply for the 462 and 462 would get granted, then you would have applied for 189 and you would come to Australia on 462 and you've been waiting for the 189 decision in Australia, then potentially you can get the bridging visa. So while lodging, that means more or less nothing. Lodging 189 visa. It's about time. It's about the point of time before lodgement or after lodgement, and when your 462 will be granted or not. If your 462 would be granted before 189 lodgement, different story, and granted after 189 lodgement, also different story. Studying Melbourne is compulsory for lectures, tutorials, and labs. Yes, that's the condition of the student visa. The student visa condition says that you must have at least 80% of attendance. Masters via research. Yeah, that's the interesting thing. Government decided to give full-time work rights for the people who are doing masters by research. The main idea was to give them full-time work rights so people can do their work as part of their research and getting paid for that. Okay, so that was the main idea. However, it's not being stipulated in the visa condition, so potentially you can have the full-time work rights. But yeah, working full-time and studying full-time, I'm not sure if you would be able to, but interestingly, during the COVID, Home Affairs decided that they will. It's not like they allowed people to work full time. They said that the case officer will use their discretion and not to cancel the visa if you will be in the breach of the visa condition working full time. Crazy. But yes, potentially you can work full time because the condition does not say that work full time must be for the research. So you can work, but remember about the condition that you also must study, do whatever is the condition of your course. All right. Foreign visa application on single launch back in January 2020 got stuck during COVID pandemic. Visa granted September 22 after Australian border opened. Adelaide, February 23. Have a kid with my girlfriend, not the facto relationship, born in November 20. Kids almost 3 years old. Both girlfriend and kid are offshore now. Wanna bring them to Australia and get married. Need guidance on how to proceed. Hoo-ha. Alright, so not the fact relationship, girlfriend and kid. Yeah, that's a tricky situation. So I'm assuming you didn't advise Home Affairs that you got a kid while you've been waiting for the. Is that September 20, visa lodged 20? Granted September, November 20. Yeah, right. So visa lodged January, kid born 10 months later, kid almost 3 years old. Yeah, you can make an argument that you haven't been in the relationship, but that's that's sort of fishy. That you haven't been in the relationship, now you are in the relationship, and you decided to be the responsible parent, responsible father, and you decided that actually mother of your kid, it became serious. So creating some sort of the story, it may work. Probably the safest would be bringing them to Australia on the visitor visa, if possible. I don't know where you are from, and with visitor visa, some countries you are just waiving the passport, and from some countries, Mission Impossible. Probably the best way forward, getting them to Australia on the visitor visa, and then applying for the 491 as the subsequent entrant for your partner and the kid. And if anything would go wrong, then there's always the possibility to appeal. All right, so offshore, different story. Yeah, bit fishy over here. If you would have advised Home Affairs that you are in the relationship, probably you would have lost 10 points for being single, and in such a situation, you wouldn't get your 491 granted, and that's a quite common scenario. and it's quite ridiculous what Home Affairs is doing. People are waiting for 2 3 years to get their visa decided, and life is happening. But well, it's brutal, but that's the situation. And I believe there could be quite a few applications like that in the system. People are waiting, and yeah, we'll see what's gonna be the Home Affairs approach, whether to grant or to refuse. But honestly, Australia needs skilled people, so if they would start refusing, that would be just unreasonable. But yeah, carefully plan. You need to plan this one carefully, and you need to make all of the dates right. Because if you will say that you have been in the relationship before the visa grant, instead of getting the visa, you may actually get your visa cancelled. All right, so be careful with that. What else? Hello everyone, is there any good positive ITSL skills assessment, bachelor of education, 45 days training is mandatory. Quite a few people, I believe, went through this process. This 45 days training is mandatory, so there is no way you can get away with that. And that's what AITSL is looking at, whether you have had these 45 days or not. And I've seen a couple of people who get it unsuccessful because they haven't had the training. And essentially, to get the skills assessment, if you have got the bachelor, you can do the graduate diploma in teaching, 12 months of studying in Australia. You can do that on the student visa, and you can do that on 485, why not? And after that, you may get the skills assessment as the teacher, primary, secondary, pre primary. That's doable. But 45 days of training is mandatory. No ifs, no buts. You must have 45 days of training. American and my wife is Australian. We're looking to move to Australia next February. However, I'm trying to figure out the best way to enter Australia on a visa. But it is November, February, 3 months. If you're in the long-term relationship, it's all about timing. With U.S. Passports, getting ETA, it's almost instant most of the time. If you haven't got any history about coming to Australia, not coming, being naughty, whatever, you can get the ETA. You can get the ETA, then you're coming with your partner to Australia on the ETA and applying for the partner visa. While on ETA, 3 months with no work rights, and once you jump on the bridging visa, then you will be with the full-time work rights, Medicare, happy days, and you can wait in Australia. But if the work rights is very, very important part of the deal, probably applying for the partner visa while you are still overseas is the best idea. But February, 3 months, it is very unlikely that you will get the visa by that time. And if it's offshore application, I believe Washington, Australian post in Washington, will be assessing your visa application. They are quite quick, but still, quite dependent on how many applications have they got, what are their priorities, and so on and so on. But yeah, way forward, either ETA coming to Australia and applying for the partner visa while in Australia, or applying for the partner visa offshore. Once the partner visa granted, then you are coming. If you apply for the partner visa offshore, then ETA, and then you will come to Australia on the ETA. Um, I believe you will have to leave Australia once they will be in the position to make a decision about your partner visa. The concession periods, COVID concession periods, just expired yesterday. So the partner visa applications lodged offshore. I believe the new ones will have to go overseas, back overseas, because for the offshore applications, partner visa offshore applications, you must be also offshore at the time of decision. All right. During the COVID, they were allowing people to be in Australia, but now it's back to as it used to be. So they will very likely ask you to leave Australia. If you come on the visitor, you will apply offshore, then ETA, then coming to Australia on ETA, and hoping that you will be able to wait and get it granted in Australia. So probably ETA, come to Australia, apply for the partner visa while in Australia, then you will get the bridging visa. Um, but it all depends on your plans, on your ability not to work for a couple of months in Australia, whether you can wait a bit more and get for your partner visa grant, just assuming that your partner visa will be granted overseas, and then you can come to Australia with the full-time work rights. Happy days, you can start working. Just starting the process of applying for the 190 QLD. I'm just in the middle of doing my skills assessment, applying for the 190 visa. Confidence. Up to 120 days to be approved, but my current visa is up in April next year, and after starting the process way too late. As well, get my skills back, then apply for the EOI and wait for my invitation to apply for the visa itself. Yeah, listen, apply for the 190 visa. Confidence, yeah, your confidence is freaking great, but the thing is that when we are talking about the skilled visas 189, 190, 491s, there is a lot of ifs and buts, and there is absolutely no certainty that you can get invited. The skilled visas are by invitation only, and honestly, quite often the skilled visa, especially in current scenario when states are having very very low quotas for the invitations, could be taken with a grain of salt. And skilled visa probably should be plan B. If you have got 485 for another couple of years and you are working in your nominated occupation, chances are that sooner or later you will get invited. However, if you are, fresh graduate and your visa is about to expire, you don't have work experience, and you are having, low points, and your occupation is not that in demand, then assuming that you will get invited for the skilled visa, you might get surprised. So applying for the 190 visa, I would say that I'm now applying for the 190 visa once I would get the invitation. But in your situation, a couple of months of waiting for the skills assessment, and then you don't really have the time to deal with the EOI and invitation and everything. Probably think about Plan B. What other visa you can apply? The free ride, fortunately or unfortunately, is over. So the 408 COVID visa is gone. Only those who are already on the 408 may apply for another one, but keep in mind you will have to pay for it, and you will get it just for half a year. $405, and everybody is thinking it's just $405 and that's it. Most of the time there is another $700 for the subsequent temporary visa application charge. So if you are applying for the second, third, fourth temporary visa application in Australia, there is this additional $700, and a couple of people already got this nasty price. So if you were in Australia on the working holiday, then 408, then 408. Now you are applying for another 408. No, it's not 405. It's gonna be 1,105 plus about 1%, 1.4% credit card surcharge. So visa for half a year, 1,120, $30. So keep that in mind. So applying for the 190 visa, you are not applying for 190 visa unless you will get invited. And Queensland has got quite a low quota for invitations, so time is not on your side. So think about what other visa you will potentially be applying for once you will get your skills assessment. And also keep in mind that Queensland is not inviting people on the student visa. So if your only option is to jump on the student visa, then you've got a problem. If you are on 408, yeah, happy days. If you jump on the student visa, you've got a problem. All right. Why Queensland is not inviting people on the student visa? Queensland is saying that you must have worked in your nominated occupation for 3 months or 6 months, or not necessarily, but it's at least 30 hours per week. On the student visa, you have got 48 hours per fortnight, which is 24 hours per week. So Queensland student visa, people on the student visa are not being invited. Keep that in mind. So if you're on the 408, once your 408 will be over, if you will have no other choice, you will jump on the student visa, end of story. There is no way you can get invited by Queensland unless they will change the rules. But Queensland is not getting that many places. So I don't think if they will be inviting any people on the student visas in the future, in the near future, unless we get back to the situation from 2016-17, where there were thousands and thousands and thousands of places for 189, 190, for 89 at that time. Help us in that matter. So I think if we returned from Australia with the help of as my students explained, I will stay here. There was naive and courage, to be honest, but at least have come so far enough, change a lot. Long story short, when on my way back from Australia, Nowak Migration at the airport are handed me any paper stating my ban term or ban, nor was there any stamp on my passport. How would I know if I was banned from coming back and how long was the ban? Yeah, listen, this people are calling it 3 years ban, but in the matter of fact, it's not ban as such. If you would have applied, if you would be able to apply 3 years, 3 years sort of exclusion period. But the thing is, if you would apply for a permanent visa, let's say 189, 190, ENS, this 3 years exclusion period does not apply. Okay, so you can within these 3 years you can apply for the permanent visa if you would have such opportunity to apply for the permanent visa offshore. Most of the temporary visas, if you would apply within this 3 years exclusion period, you may potentially get the visa, but you would have to have an argument that there are compelling or compassionate, or both of those. I don't remember how is it worded exactly. However, those circumstances must be affecting Australian business, Australian citizen, or permanent residence. So it's not about you; it's about Australia, Australian business citizen. And those circumstances must be, compelling if you will be applying for a temporary visa. And yeah, there are the situations where people have applied for the student visa, overstayed, still studying because they forgot to renew, and then leaving Australia because they have had, and then applying, and potentially case officers, if you are lucky, you will put some argument over there. They may give you another student visa while you are overseas, and they will allow you to finish your study in Australia. But if you overstayed for months, years without really any particular reason, then getting back, it's quite often mission impossible. And yes, you are right. There are no stamps, nothing. They will not tell you. You need to know. If you don't know, talk to the professional, talk to the migration agent who is familiar with the situation. And interestingly, if you would have overstayed your visa for up to 28 days, this exclusion period, if you would have left Australia within 28 days after the expiry of your visa, this exclusion period would not apply. Of course, they would be red flag once you would be applying for another visa. But yeah, this 3 years of exclusion period normally would not apply. Interestingly, even if within this 28 days period of time you would have applied for the bridging visa E, based on the fact that you are leaving Australia, it could be more than 28 days to avoid this exclusion period. Legislation is a bit tricky, and sometimes applying for the BVE and then another BVE, because if you are unlawful, the only most of the time the only way to get away with murder, get any visa is the BVE. Although not always. Within 28 days, sometimes student visa, sometimes visitor visa, sometimes some other visa within this 28 magic period of time. Uh, if you would overstay your visa, consult professional. We have had the situations where we get some people of the hot water within these 28 days. 28 days. That's 28 days after the expiry of your visa. That's very, very important. If you will miss the boat, end of story. So 3 years, usually it's 3 years, unless it was under the character. If you would be under Section 501 character, it's a lifetime ban. You cannot come back to Australia. No ifs, no buts. And there were situations where people have had, Australian children. They got imprisoned and then tried to. Their visa was cancelled, and then they tried to revoke the cancellation. They couldn't. They were removed from Australia, not deported, removed from Australia, and they cannot come back. Section 501, it's lifetime. Okay. My national ID card number is 6, which I need to provide the evidence for the. Maybe not ban, but sorry, no advertising over here. But every registered agent in my region but knows the basics of subclass 482. The intensives can put on some I know they need help to how to become a business sponsor nomination. How to become a business sponsor and nomination? It's on employer, it's not on you. And I believe most of the agents over there are every registered agent in my region in Pakistan. So interestingly, I don't know if there are any registered agents, probably educational agents. Listen, talk to some agents in Australia, but how to become a business sponsor and nomination? It's an employer. If you're running the overseas business, potentially you can become the business sponsor and potentially you can become a nominator. So under 482, there is sponsorship, nomination, and the visa application. Normally, it's under the SBA, Standard Business Sponsorship for Australian businesses. There is also something called OBS, Overseas Business Sponsor, where overseas businesses could become a sponsor for 482 visa. But in such a situation, you will have to have some sort of the argument or case why you want to sponsor somebody to work in Australia. If you want to establish a new business in Australia for whatever reason, that's fine. If you have got the contract with some Australian business, that's fine. You can do the 482 visa as well. But quite often subclass 400 is better in such a situations if it is a short-term project, okay? But if you're just single person thinking about getting 482 visa, sponsoring yourself for 482 visa, forget about that. Pakistan, if you're a fresh graduate in engineering, 476 is quite good visa. You get it for I think year and a half, and you can come to Australia. But if you are not, well, talk to the proper migration agent. So go to nowak.us.me/es to the consultation about employer sponsored visa. HTTPS. Okay. For this post, Steve says if see migrations agreement and I'm the same for job and what it does like in my application, I still application days ago in Metroact, how true it is. It's not true. It's dependent on your occupation and dependent on the visa type, whether your occupation is on the priority list or not. Australian visa tips. Yeah, I know this fella. I like him actually. Another one. Visa tips. Bada. Support working for residential aged care providers. Does it count as the community worker job role? That's a different occupation. What are the chances to get 190, 189 under that category with 1 year of experience? Qualifications, graduate diploma, good job based on my experience, healthcare. Listen, residential aged care providers, there is the special labor agreement, aged care. Honestly, probably that's something age of disabled carer. Okay, so that's something you should discuss with your employer. Here's details for aged care labor agreement Talk to an employer if they want to get into this labor agreement, because honestly, I'm not sure if you are a support worker or if you are carer. But yeah, if you don't have qualifications, there is no way you can get the skills assessment. If you cannot get the skills assessment, there is no way you can get 190 or 189. And even if it would be support worker, 190 yes, 189, there is no way you can get 189 because it's not on this. It's not on this. Not on this what? Not occupation is not on. It's not on this list of occupations. Okay. What else? Uh, would like to ask. Yeah, so it's not easy to answer the question straight away. Would like to ask if anyone has applied for a visitor visa for someone for the visa to come out. The time frame the visitor is given to stay in Australia. Being on 189 visa and applying for the visitor visa for someone, essentially generally you cannot apply the visa for someone. You can assist them and tell them what to do, but yeah, it's a fine line. If you are not migration agent or migration lawyer, you shouldn't be applying for the visa or assisting with the visa applications for whoever. So honestly, this question is a bit odd. For my one offshore applicant, my visa is in process. I'm going to another country for holidays. Could you please guide how to update because I didn't find an option. There's option changes with circumstances probably. There is the option changes of circumstances, but if it's a couple of days, less than 12 months within last 10 years, not really big things. So it's up to you. You can just put into the changes with circumstances if you really want to. Technical interview, occupation carpenter. Wondering what sort of questions they could be asking. Your help would be much appreciated. Yeah, listen, the questions which are being asked, if you are talking about the JRP or OSAP, um, technical interview. So that would be very likely OSAP, Overseas Skills Assessment Program. The questions are related to the qualifications. So whatever would be the subjects which would be taught during the carpentry course, those questions are most of the time related to that one because as part of the OSAP, they you will also get the certificate training in carpentry. All right, so they're asking questions relevant to the qualifications most of the time, most of those. So go to the chat. What's the name? Not trades. Jeez, I forgot. Next time. Waiting for 491 grant since 2021. Wow, 2 years. City category in February 23. I'm an offshore applicant. Can I change my job now? Why the white for the grant? Yeah, listen. The 190, 491, 189. The requirements is time of application. So you have to prove evidence all of the points at the time of invitation, the time of invitation. So at the time of invitation, you must have all of the work experience. If you will change the job 190 offshore, in theory, state can withdraw the nomination, but I haven't heard about any state withdrawing the nomination before the visa grant. But if you're an offshore applicant, probably New South Wales wouldn't really be upset if you would change the job. The states are upset if you are moving to another state before the visa grant because that's not what they want. But yeah, offshore applicant changing the job, and I don't see any big dramas over here. commencement email bad sign. Yeah, with these commencement emails, Home Office is very inconsistent. Sometimes out of nowhere they are sending these commencement emails, and then after a couple of weeks, people are getting decisions. I saw sometimes they are sending commencement emails, nothing is happening. A few months later, they are sending commencement emails again, and nothing is happening. And then 1 year later, the visas are being granted. Nothing to worry. They are very inconsistent. So sometimes they are sending those emails, but most of the time not. Why they are sending those emails, I don't know. It's nice, but well. There must be specific criteria including demonstrating the genuine need for the nominated position within their organization. Yes, so 482 essentially the application must make sense. The nomination, the position must make sense within the company's operation. Restaurant, chef, cook, restaurant manager, no brainer. But if restaurant would be willing to sponsor plumber, is the position genuine? Probably not, so it would be refused. 23rd November, congratulations. Multiple wise for 190 visa, for example, Victoria, 189 visa for Sydney. 189 is not dependent on the states, so 190 for Victoria, 190 for New South Wales, I would say, yes, that's possible. But here is the big question whether you are in Australia or overseas. If you're in Australia, states are generally inviting only those people who are living in Australia. States are inviting only those people who are living in the particular states, not in the other states. Western Australia is the only sort of exemption. They are inviting people from the other states. But most of the time, you would have to have at least the genuine job offer. For this no question, for this after receiving the grant letter, like for example, reply to them to accept the grant within a certain time frame. Would like to thank everyone in the job. Yes, probably having a party. It's mandatory, all right. But apart from that, not really. Engineering technologies. Well done. Yeah, listen. I will leave it there. So yeah, hopefully you will get some information out of this. Ad hoc questions, answers. If you need immigration advice, consult with the professional. Go to nowak.us.me. We are offering the free and paid consultations for the different situations: partner visa, employer-sponsored visa, skilled visa, whatever. We are assisting people with various visa applications. So go over there, book the consultation with myself or one of other agents over here. And yeah, we can have a look whether, if, how we can assist with your journey to Australia, with your Australian dream, with your life in Australia. All right. So thank you very much for being with me, and yeah, I will speak to you later. Bye bye.